Nancy Adkinson, docket numbers 96-234 and 96-1230. The defendant is present. Counsel, would you please introduce yourselves?
Good afternoon, Your Honor. Kevin Curtin, Assistant District Attorney for Middlesex on behalf of the Commonwealth.
Good afternoon.
Good afternoon, Your Honor. Robert Sinsheimer for Ms. Adkinson.
Good afternoon. Could I see Counsel sidebar, please? Okay, why don't I hear from the Commonwealth?
Your Honor, the Commonwealth requests that bail be set in the amount of $100,000 cash with conditions that the defendant be ordered to have no contact with the victim's direct or indirect until such victim contacts her. The reasons for setting this cash bail are that this is the bail that was previously set in this matter in April of 1996. Since that time, the defendant, it's true, has accrued significant time credit towards a 35 to 40-year sentence. However, a couple of things have happened to significantly affect her position in a negative way. Motion to suppress confession has been denied, and she's been convicted of these crimes. I know that the court has read my request and not in my paper, and for that reason, that's what I'm asking. The Commonwealth has a strong case, Judge. The defendant still is facing 16 offenses, 4 counts of rape of a child, 3 counts of indecent assault and battery on a child, and together with 9 other charges. This is a case where the defendant gave a full signed confession. In the confession, she acknowledged details of the crime that were later independently, separately corroborated by each of the children in 3 different settings under circumstances in which they would have had no way to know what she had told police. At the trial, the defendant's own expert said that the gold standard for the reliability of child reports of sexual abuse would be an instance where the defendant confesses. And that's the kind of a case we have here. I do have more to say about what is the exposure that the defendant is facing with respect to punishment. She has received a very significant sentence. The reason for the reversal in this case has nothing to do with her substantive liability for the crimes. It was only she was incompetent to stand trial. She's not excused or justified in her conduct. Nothing that the appeals court said in its decision indicates that being incompetent to stand trial by reason of battered woman syndrome excuses or justifies crimes against innocent third parties. The defendant has she faces a significant possibility of incarceration still. One of the main factors in sentencing is, as the Commonwealth argued initially in its sentencing memorandum, an acknowledgement by the perpetrator. And in this case, Judge, we have not had anything like that. In her original confession, she essentially shifted responsibility for the drugging and sexual abuse of the children onto her husband. At the hearing on the motion for new trial, she again testified at trial in substantially the same way. At the hearing on the motion for new trial, she again did not acknowledge responsibility for these terrible crimes. It was all about how she was the victim. And it seemed to me, Your Honor, that she was prepared to say anything that she thought would get her off the hook. And we never once heard anything like, "I'm so sorry. I can't believe that I perpetrated these devastating crimes against my own children. I subjected them to incredible exploitation. I can't believe that that happened. When they needed me, I destroyed them. Look at the evil that I've done to my own children. Look at what I've done. I'm so sorry." We haven't heard anything about that. Not yet. And as we said, as Special Assistant District Attorney Martha Coakley said in her sentencing memo, the first step, particularly in cases like this, to any satisfactory rehabilitation has to be an acknowledgement by the perpetrator that she's committed the acts and is willing to work to modify behavior which results in the victimization of the children. And in this case, Nancy Adkinson, to the extent that she was willing to tolerate and participate in behavior by her husband upon her 4 children, and up to then, and so far as has been clearly demonstrated to this court, has refused to seek assistance in her own rehabilitation, although I understand that she has sought some rehabilitation since she's been incarcerated. She still presents a frustrating case on the record that we have before us for the criminal justice system, seeking rehabilitation of offenders. And until she acknowledges her wrongdoing, the goal of rehabilitation is distant and unrealistic. That was what the Commonwealth said in 1997, and unless something's changed, that's the same position that we have today. So she still faces the significant possibility of additional incarceration based on the record and the showing that she's made to the court. Thank you.
Thank you, Mr. Kirk. Attorney Van
Judge, what I'm suggesting is that this hearing essentially be postponed to as short a date as is reasonable. And let me be clear why I phrase it that way. I understand that you'll have to set some kind of bail. And I'm only asking at this point, in this day, that whatever you do with this without prejudice, but I mean totally without prejudice. Not without prejudice in the sense that we have to come back with something new. Because if I have to, I would argue today at length and with very good faith reason that she should be released immediately on person. But what I'd like to do is just simply have a little more time to prepare that. And let me tell you why I need it. I want to be very, very careful how I phrase this because resolution-type discussions are not necessarily something that the court should hear about. And I certainly don't want to disclose anything that is intended to be privileged. But all I can say is I've had 2 lengthy discussions with senior assistant district attorneys, one in particular, Liz Keeley in the Commonwealth. And it was my understanding that we were getting close. And I just want to leave it at that, unless my brother wants to add to it. And the reason why I say it that way is that it's nothing final, nothing binding. I want to be very, very clear about that. Nothing final, nothing binding, and they promised nothing. But I'm speaking for me. It was my understanding we were getting close. Now, even a single day of freedom is something that one must think about as a very, very serious matter. But notwithstanding that, with the understanding that I had, I felt that I would press for bail today, and I made that very, very clear to my brother. I think that's the phrase I used, was I'm not going to contest it at all. But I want to be careful procedurally that she doesn't get locked in. If it turns out we don't get anywhere, and we have to set the thing up for trial, because she shouldn't be held on bail. If you want, I can give you sort of the nutshell reasons, but I'd like, and I can come back as soon as tomorrow. I could be here tomorrow afternoon to argue. I want to have a memo. If you want the nutshell reasons, let me share it with you. First of all, I disagree respectfully with my brother about what she's facing, because she never had any record, Your Honor. She's 49 years old. Regardless of what he says about the conviction, she's innocent until proven guilty. So she sits here as someone looking at a trial with no record, 49 years old. If we were to look at the Massachusetts guidelines, she would be looking at something like 40 to 60 months if she was convicted of everything. And she's already done 16 years. So right there, even if you assume guilt, it's the idea that she's really looking at more time, I suggest, for some reason. Second bullet point. These are just bullet points because I want to have an opportunity to expand on this in a written presentation if you'll allow it for me. Second bullet point. $100,000 was set 16 years ago, so we want the same number. That's the government's position. But if you look at what happened 16 years ago, she went through this entire proceeding under the control of a batterer. That's why she's here today, innocent until proven guilty. She was not her own person when she was in court as a waif under the control of one of the most sadistic human beings that's ever faced the courts of the Commonwealth of Massachusetts. She didn't argue anything. She didn't present the reasons why she had a right to be free. Third, they talk about her confession, but then they also mention, because they have to, In her so-called confession, she mentioned the battery, but no one made enough of it. So that's enough. If all I'm really asking for, Your Honor, give me a little more time to give you a more thorough presentation, which will include, specifically, if she were to make bail, where we would like her to be. And part of the discussion I've had with the government is preparing for re-entry. We have a place for her. We have people who will be in. We have potential employment for her. We will talk about the bracelet. We will talk about safety of the community of a 49-year-old person as opposed to a 20-year-old person. So just give me a little more time, Your Honor, unless you can't, then let me go on. But my hope is that I'll come back as soon as tomorrow, but I definitely would like it to be before Thanksgiving.
All right, thank you, Attorney Sincharma. Bail is set at $100,000 cash without prejudice. That's a cash-only bail, no surety alternative. The defendant is ordered to have no contact with the victim, direct or indirect, unless the victim, or at this point, alleged victim, should contact her. Okay, so are there two completely separate cases?
They're related, Your Honor.
They're unrelated?
They are related.
They are related.
There was a...
should I set bail at $50,000 cash on each?
That would make sense, Your Honor.
Yes, please.
Adkinson, Adkinson on and back numbers 96-234 and 96-1230 is ordered by the court that you recognize on both cases in the amount of $50,000 cash bail. That bail is set without prejudice with the following condition: that you have no contact directly or indirectly with any of the alleged victims in this matter unless they initiate said contact. Do you understand that, ma'am?
Yes, I do.
So recognizes, ma'am. You're also notified that if you do make bail, that commission of a crime may result in revocation of your bail. You may be held without bail, and failure to appear can result in a fine of $50,000 and or 5 years in the state prison or 2.5 years in house of correction. Understand that? Thank you very much. So recognizes.
Okay.
Anything else, counsel?
Well, yeah, two things. I guess we need to set the date for a pre-trial conference, but also, maybe I wasn't clear, or maybe I misunderstood what the court did. I want a date to really argue bail, present a petition with the real kind of data, and I'll take as soon as tomorrow.
Oh, we can't do it tomorrow.
Well, I understood that, but I'm really expressing the...
What date? Yeah, I don't mean to interrupt you, but I don't have any problem.
The only date that I personally can do it between now and the 28th is the 23rd, which is the Wednesday before Thanksgiving. I can have Ms. Thomas here, and I know the court made some comments about that sidebar, on the 16th. And she'd be able to do this.
All I told you was that Ms. Thomas is my former student. I don't see that as a difficulty.
No, but since I mentioned the name out loud,
the Wednesday before Thanksgiving, what does the Commonwealth think about that? If I had to guess, I would say that it's probably not going to appear before me anyway. I mean, there's not another day that you can have...
I'm out for most of December, starting on the 28th of November for personal reasons, which I disclosed to the Commonwealth. But in any event, bail, I don't want to hold that long, even if I think Ms. Thomas could do it the 18th as well.
So why don't you, could you still kind of just speak with each other for a moment and see if you get a date that works? I don't think we should turn the court schedule on its head. And I think that we can accommodate it before Thanksgiving. I just think you ought to agree on a date.
Maybe, Your Honor, 2 dates would make sense if we're going to have a tentative date in case the defendant's going to file something additional. He says that there may be some new information relative to the question of bail that we haven't seen yet. I don't know. I don't have a problem with if the defendant makes some further showings on the question of bail coming in on a reasonable date, and I am here the 23rd. But the only problem that I have is that if there is going to be anything other than that before Thanksgiving, I want to be in a position to be ready.
No, if we can have what I would say is a real bail argument on the 23rd, I'm comfortable with that, and I'm comfortable giving the government more time, both to prepare for trial and to continue the discussions we've had.
All right, so you can file whatever you're going to file 7 days before?
Absolutely, the 16th.
All right. So November 16th is out of court, not in court, for the Atkinson to file whatever it is that she wants to file. And then the case will be in court on the 23rd. Is that going to be at 9:30 in the morning?
I would hope so. I don't want to come in the afternoon.
Thank you, Your Honor.
Thank you, Your Honor, very much.
It's before whoever the regional administrative judge indicates. Doesn't matter.
Okay, so I would calendar 6:30, then you should be classified.
Right, right. I'm happy to do it. I'll be here.
Should we get a further date?
You probably should get a pre-trial conference date.
More toward the end of December, I'll be available. Anytime the government wants after the 14th, I'll come.
Okay.
I'm not taking Christmas this year.
The entire week of the 19th is available to me, I believe.
That works.
Day, Council.
But
How about the 20? All right, the 20th then. That's a Tuesday at 2 o'clock for pre-trial conference.
That's fine, Your Honor, thank you.
All right, thank you. Have a good day.
thank you very much.
Number 16, filing deadline.
One moment, please. I'm sorry. Okay, if you're here for a civil case, we have to change courtrooms. I don't know if anyone's here for a civil case. All right, we're going to have to go back because of mechanical problems here. We're going to have to go back to room 520. So if you're here for a civil case, I'll see you in room 520. Thank you, everyone. Have a good day.
Okay, recess.
David,
All rise.
yeah, I'll give you the bill.
Thank you.